Washington is a city built on the architecture of the strategic silence. It is a place where the unwritten code of the elite, the protection of the guild, usually outweighs the demand for transparency. But at 6:08 a.m. this morning, that code didn't just crack, it was vaporized. Vice President J.D. Vance has just moved a pawn that threatens the entire board. He has gone on the record with the existence of a relational database, not a mere list, not a leaked memo, but a structured digital forensic record of the Jeffrey Epstein enterprise that was never intended to see the light of day. And sitting at the epicenter of this data, embedded within the metadata of the most notorious sex trafficking ring in modern history, is a name that sends a shiver through the bedrock of the federal government: Judge Caldwell. A sitting federal judge, a man with lifetime tenure, a man who, as we speak, holds the power to sign warrants, sentence citizens, and interpret the Constitution. According to the Vice President, Judge Caldwell's name appears 114 times. This isn't a clerical error. It isn't a CC on a stray email. In the world of federal investigations, 114 entries suggest a pattern of conduct. It suggests an ongoing, calibrated relationship. The institutional reflex in this town is always to circle the wagons, to prioritize the stability of the judiciary over the accountability of the individual. But Vance has bypassed the usual gatekeepers. By putting this on the official record, he has created a structural risk to the federal bench that cannot be ignored, minimized, or buried by a Friday evening news dump. The question we have to ask ourselves today is not just who is Judge Caldwell, but what happens to the rule of law when the person presiding over the bench is allegedly documented in the archives of a blackmail syndicate. This is the fracture point. The guardrails are off. The quiet story is now the only story. To understand why this matters, you have to look at the paperwork, or in this case, the metadata. When Vice President Vance stepped to the podium, he wasn't just offering a political soundbite. He was executing a calculated strike against the strategic silence that has protected the Epstein network for 2 decades. He didn't refer to a list. He referred to a relational database. In the world of high-stakes litigation, that distinction is everything. A list is a static document. A relational database is a living map of influence. It tracks the who, the when, and, most importantly, the linkages between nodes of power. Here is the breakdown of the disclosure and the intent behind it. The Vice President revealed that this database was synthesized from the 2019 raids on Epstein's Manhattan and Virgin Islands properties. It includes forensic mirrors of encrypted servers and physical logs. This is the material the Department of Justice has held in a state of institutional reflex for years, protecting the system by keeping the data under seal. By detonating this information now, Vance is effectively telling the DOJ and the Administrative Office of the Courts that the era of internal containment is over. Now, look at the number, 114. In a federal investigation, frequency is a proxy for intimacy. Judge Caldwell's name appearing 114 times suggests he wasn't a guest, he was a fixture. The data, according to Vance, is categorized into 4 lethal buckets: direct communication logs, digital fingerprints of outreach to Epstein's scheduling coordinators, event coordination, records placing Caldwell at the centers of gravity, the Manhattan townhouse and the Caribbean estate, financial reference codes, alphanumeric strings that investigators believe correlate to the movement of value, the leverage files, tagged entries that suggest Epstein's operation was actively cataloging Caldwell for the purpose of future strategic silence. But here is where the story takes a darker turn. Vance highlighted a specific entry from 2010. Remember the timeline. This is 2 years after Epstein's infamous non-prosecution agreement in Florida. The entry reads, Caldwell confirmed for weekend legal discussion with GM. GM is Ghislaine Maxwell. Let that sink in. A sitting federal judge tasked with upholding the integrity of the United States courts allegedly scheduled a legal discussion with the primary facilitator of a global trafficking ring while she was under the shadow of federal scrutiny. This isn't just a lapse in judgment, it's a potential obstruction of justice. The vice president's intent here is clear. He is bypassing the traditional guardrails of the Justice Department to force a mathematical inevitability. By making these specific entries public, he has made it legally impossible for the House Judiciary Committee to remain silent. He has effectively stripped Judge Caldwell of his institutional immunity and placed him squarely in the crosshairs of an impeachment inquiry. But why now? To understand the timing, you have to look at the fragility of the institutions. The administration isn't just draining the swamp, they are conducting a forensic audit of the people who represent the last line of defense for the establishment. They are showing that even a lifetime appointment is not a shield against the forensic reality of a relational database. To understand why this is a five-alarm fire for the federal judiciary, we have to look at the historical ghosts haunting the halls of the Supreme Court and the specific legal mechanics that protect and now threaten Judge Caldwell. In the history of the American experiment, the federal bench is supposed to be the least dangerous branch, insulated from the whims of politics by lifetime tenure. But that tenure is not absolute. Article 3, Section 1 of the Constitution contains a four-word trapdoor: during good behavior. When J.D. Vance cites 114 entries in a trafficking database, he isn't just making a political accusation. He is triggering a constitutional challenge to that good behavior standard. We have seen this play out before, but never with stakes this high. Look back to 1969. Justice Abe Fortas was a titan of the liberal establishment, a sitting Supreme Court justice. But when it was revealed he had accepted a $20,000 annual retainer from the family foundation of a man under investigation for securities violations, the institutional reflex was swift. Even without a direct smoking gun of a ruling being bought, the mere stench of the connection made his position untenable. Fortas became the first and only Supreme Court justice to resign under the threat of impeachment. The Fortas precedent tells us that the judiciary cannot survive the perception that its members are on a retainer for the powerful. But what Vance is describing with Judge Caldwell goes light years beyond a $20,000 retainer. We are talking about the potential for strategic silence bought through a blackmail syndicate. The legal mechanics here are brutal and rare. Under Article 2, Section 4, a federal judge can only be removed through impeachment for high crimes and misdemeanors. The House must vote to impeach, acting as the grand jury, and the Senate must convict with a two-thirds majority. Since 1789, only 15 federal judges have been impeached. Only 8 have been convicted and removed. But here is where the strategic scenarios come into play. Scenario 1, the Fortas exit. The Judicial Conference of the United States, led by the Chief Justice, exerts immense private pressure on Caldwell to resign, to save the institutional integrity of the court. This is the system's way of cauterizing the wound before a public trial. Scenario 2, the full impeachment. If Caldwell refuses to move, we enter a constitutional crisis. The House Judiciary Committee will subpoena the full relational database. We will see the paper trail in prime time. Every ruling Caldwell ever made, every suppression of evidence, every sentencing reduction for a well-connected defendant will be scrutinized through the lens of those 114 entries. To understand the gravity, look at the actuarial risk to the justice system. If a judge is found to be compromised, every single person he sentenced, every corporation he ruled against, and every victim who didn't get justice in his courtroom has a legitimate claim for a retrial. We aren't just looking at the removal of one man. We are looking at the potential nullification of 20 years of federal jurisprudence. The guardrails weren't designed for a collision of this magnitude. They were designed for bad behavior, like public intoxication or small-scale bribery. They were never meant to handle a sitting judge embedded in a global leverage file operation. This is why the panic in Washington is so palpable. The system is realizing its primary defense mechanism, lifetime tenure, has been transformed into a permanent vulnerability. While the cameras were focused on the salacious details of the Caribbean estate and the specific number of entries, the real power shift was happening in the K Street lobbying firms and the private offices of the legal elite. To understand the strategic silence currently deafening Washington, you have to look behind the curtain at the money. This isn't just about one judge, it's about the entire infrastructure of judicial selection. For decades, there has been an unspoken agreement between both parties, the interbranch comity. You don't primary the other side's judges, and you don't weaponize their personal lives. But J.D. Vance just shredded that agreement. Behind the scenes, we are seeing an institutional reflex that borders on cardiac arrest. Here is what is happening in the shadows. First, look at the donor freeze. Our sources indicate that in the last 48 hours, major political contributors, the kind of people who fund the advocacy groups that vet these judges, have moved into a state of emergency redlining. They aren't just worried about Judge Caldwell, they are terrified of who is next in that relational database. The checks have stopped. The fundraising dinner invitations for judicial advocacy groups are being rescinded. The donor class is realizing that vetted no longer means safe. It means documented. Second, there is the quiet story within the Department of Justice. While the public-facing side of the DOJ remains silent, the career prosecutors, the ones who have been sitting on this data since 2019, are reportedly entering a phase of mathematical inevitability. They know that once a vice president puts specific metadata on the record, the institutional shield is gone. We are seeing reports of preemptive cooperation. High-level staffers who were involved in the original Epstein investigation are now reaching out to congressional committees. They are looking for guardrails for their own careers before the inevitable subpoenas fly. Third, look at the market reaction. Not the stock market, but the influence market. The major big law firms, those that frequently argue before the federal bench, are currently conducting an internal actuarial risk assessment. If you are a partner at a top-tier firm and you have a massive civil case currently sitting on Judge Caldwell's docket, your case is now a toxic asset. We are seeing a flurry of private motions for summary recusal. The legal establishment is trying to decouple itself from Caldwell before his inevitable collapse pulls their clients into the abyss. Why did Vance do this now? Because it changes the strategic calculus for the next decade of judicial appointments. By exposing the rot in the current bench, the administration is effectively clearing the field. They are telling the establishment that the old vetting process, the one that allowed a man with 114 entries in a trafficking database to rise to the federal bench, is fundamentally broken. This isn't just a hit piece, it is a structural realignment. While the media talks about the scandal, the administration is busy rewriting the rules of who gets to wear the black robe. They are moving the pieces to ensure that the next generation of judges is beholden to a new standard of transparency, one where the quiet story is finally brought into the light. The response from Judge Caldwell's legal team and his defenders in the establishment has been as predictable as it is desperate. They have retreated to the last bunker of the compromised, the process defense. Their statement, and I want to be very precise about their language, called this disclosure a dangerous assault on judicial independence and politically motivated character assassination. They're leaning heavily on the concept of the institutional reflex, hoping the public will prioritize the abstract sanctity of the court over the concrete evidence of corruption. But let's systematically dismantle that narrative with the cold logic of the law. First, the independence argument. They claim that the vice president is weaponizing a database to intimidate a sitting judge. Here is the reality. Judicial independence was designed to protect judges from being punished for their rulings, not to shield them from their records. Independence is not a license for impunity. When a judge's name appears 114 times in the forensic records of a sex trafficking operation, the threat to the judiciary isn't the disclosure, it's the conduct. To argue that exposing a potential blackmail target is an attack on the bench is to argue that the bench is only independent when it is allowed to be corrupt in secret. Second, the unverified argument. The defense calls this an unverified database. This is a classic strategic silence tactic. This data didn't fall off the back of a truck. It originated from FBI seizures, DOJ forensic mirrors, and physical logs recovered from Epstein's properties. If the database is unverified, then the evidence used to convict Ghislaine Maxwell is unverified. You cannot have it both ways. The fact that the Department of Justice has sat on this for years doesn't make it unverified. It makes the DOJ an accessory to a cover-up. Third, the guilt by association defense. They say contact with a criminal is not a crime. In a vacuum, that's true. But 114 entries create a mathematical inevitability that association has evolved into coordination. If I have one entry in a log, it's a mistake. If I have 5, it's an acquaintance. If I have 114 entries, including legal discussions with the primary facilitator, I am a participant. The defense has notably failed to provide a single substantive denial of the specific meetings or the specific 2010 weekend mentioned by the vice president. When you attack the messenger but ignore the metadata, you aren't defending your innocence, you are managing your collapse. Finally, they argue that this should have been handled through proper channels, the internal judicial ethics committees. Let's be honest, the proper channels are where scandals go to die. The internal institutional reflex of the federal courts is designed to protect the good behavior clause at all costs. Vance took this public because the internal guardrails failed. He didn't break the system. He exposed that the system was already broken and that the proper channels had become a strategic shield for the protected class. The other side isn't fighting for the Constitution. They're fighting for the strategic silence that allows them to maintain a two-tier justice system. And that narrative is currently being pulverized by the weight of the paper trail. We are no longer in the realm of speculation. We are in the realm of the forensic. What J.D. Vance did this morning wasn't just a disclosure, it was a deployment. By naming Judge Caldwell and citing the specific count of 114 entries, he has initiated a sequence of events that the establishment cannot stop. But for those of us watching the guardrails of this republic, the work is just beginning. This is your battle plan for the days ahead. Here is what you need to watch for, because the telltale signs of the system's collapse will happen in a very specific order. First, watch the House Judiciary Committee docket. The moment the first subpoena is issued for the raw, unredacted relational database, the strategic silence of the Department of Justice will be tested. If the DOJ resists, we are in a full-scale interbranch war. If they comply, the floodgates open. You need to watch for the domino effect. Judge Caldwell is the test case, but the vice president has already signaled that he is just the first name. The moment a second or third name is leaked, perhaps a member of the Senate or a high-ranking executive official, you will know the administration has moved from warning to liquidation. Second, watch for the preemptive resignations. In Washington, a sudden retirement to spend more time with family is often the only way a compromised official can negotiate a deal to keep their pension before the paper trail becomes public. If we see a cluster of federal judges or senior bureaucrats suddenly stepping down in the next 72 hours, consider that a confirmation of the database's reach. Third, look for the procedural sabotage. The establishment will try to move this into a special master review or a closed-door ethics committee. Do not be fooled. This is an attempt to reinstall the strategic shield. Transparency is the only disinfectant that works here. The gravity of this moment cannot be overstated. We are staring into a fracture in the very foundation of the American judiciary. For years, we were told that the Epstein files were a conspiracy theory, that the client list was a myth, and that the system was working exactly as intended. Today, we know the system was working as intended, but it was intended to protect a specific, insulated class of predators and their enablers. The fragility of our institutions is on full display. A republic cannot survive a two-tiered justice system where a federal judge can be scheduled for legal discussions with a human trafficker while ordinary citizens are crushed by the weight of the law. The rule of law is not a museum piece. It is not a static document. It is a living, breathing commitment to accountability. It requires the courage to look at the 114 entries, to follow the alphanumeric codes, and to demand that the person wearing the black robe is not a subject of the leverage files. This is the reckoning. The quiet story has ended. The era of the strategic silence is over. We will continue to track every entry, every subpoena, and every institutional failure, because at the end of the day, the only thing that protects the guardrails is the truth. I'm Kadar for Elite Dossier. Keep your eyes on the paperwork. The truth is no longer hidden. It is just waiting to be read.